Hello everyone and welcome back to Notes for Medicos. The topic that we're going to deal today is documentation from the topic of forensic medicine and toxicology. The objectives we are going to deal is the introduction, the purpose of documentation, the quality of documentation and the documentary evidence. So what do you mean by medical documentation? So it refers to any sort of written or electronically generated information. It can be about a patient or a person who has been undergoing some sort of criminal offense like rape, etc. It includes all sort of documents that can be produced for the court's inspection as well. It includes history of the past and present illness, the examinations, the tests, the treatments and the outcomes. So what's the purpose of the medical documentation? Firstly, it is to evaluate and plan immediate treatment. Second is to monitor healthcare over time. Third is to communicate and continuity of the care among the physicians for proper follow-up, then collection of the data for research and education, for audit and for legal procedures. The quality of the medical documentation is, it depends on 5 factors. First is accuracy. The medical documents should always be accurate. There should not be any sort of mistakes in it. Second is, it should be relevant. Third is its completeness. There should not be any sort of things that is missing that could affect in cases of legal cases. Next is the timeline, and the confidentiality of the patient should be very clearly managed. The documentary evidences are further divided into 3. One is the medical certificate, second is medical legal reports, and the third is the dying declaration. When we go to the medical certificate, it includes the certificate like ill health, insanity, age, death, etc. And it is accepted in a court of law only if it is signed by a qualified registered medical practitioner. And then the doctor has certain liabilities, that is the certificate should have a duplicate copy and that should be issued for 2 years, and the original copy should always be given to the patient's hand or the ones who had asked for the issuing of it. And we are legally bound to give a death certificate stating the cause of the death without charging any fee. So if the cause of the death is not known by the doctor, what we are supposed to do is, we aren't supposed to sign it until and unless we don't inspect the body on our own. And if there is a least suspicion of any sort of foul play, or if you have a doubt that it might not be the scenario that the death has occurred, we have all the rights to report to the police. So according, if a doctor issues a false certificate, previously under the section 197 of Indian Penal Code, the offense is punishable. However, now it has been changed into BNS section 234. The given picture over here is about a medical fitness certificate. The next is about the medical legal certificate. Now, medical legal certificates are those reports that are prepared by a doctor on request of an investigating officer, usually in some criminal cases like rape, assault, murder, etc. And this is and the examination is done on request for a police officer or the magistrate. And here 2 parts are observed. One is the facts that's observed on examination, and second is the opinion drawn from the facts. So the evidence is only valid if the doctor attends the court and and he or she testifies the facts under the oath. That is, I would say only truth, and apart from truth I won't say anything, by placing their hands on their holy books. And the medical legal reports should really be clear, concise, completely and legible, because this would be used in the court of laws. No negative information should be given, only the relevant ones, not the story, only the relevant ones should be given. And the reports should be written in such a way that a carbon paper should be placed under the original reports, and the duplicates shouldn't be photocopied. It should be done by only carbon sheets. The first copy of this reports should be given to the investigating officer, and the duplicate should always be remaining with the doctors for further reference. And the doctor should have the sign of have to put their sign along with the initial at the bottom of each page, if suppose the report is not staying in one page and it exceeds its length. Now we can also exhibit things like clothing, weapons, etc., describe detail post examination, and after this we have to seal it and return it to the police, and we have to obtain a receipt before handing over the exhibits to the police. The given over here is a medical legal certificate. The next is the dying declaration. Previously, this used to come under the section 32 32 1 of IEA. Currently, now the section is in 38 BSA, that is Bharatiya Sakshya Adhinayam. It is a written or oral statement of a person dying as a result of some unlawful act relating to material facts or the cause of his death or bearing on the circumstances. Here, what happens is the executive magistrate is called to record the declaration, and before that, the doctor should certify that the patient is clearly conscious and oriented to its surroundings. The mental faculties are normal before recording. That is, in forensic words, it's known as compos mentis. And here, the oath isn't administered with the belief that a dying person would always speak facts and truths, and the statement should always be recorded in their own words, and no leading questions should be asked, like why you were there, in those sort of things. But if you're having some doubt about the statement, you can ask it, like only the sentence that they have said should be asked back if you have a doubt to clarify the sentence, but the actual question and the answer received should only be recorded, and it should be based on facts and not opinions. This is also known as a verbal statement. However, this declaration is admissible in the court only if the victim who has given the dying declaration has passed away. But if the patient or the victim hasn't passed away, this isn't admissible in the court as evidence. It has a corroborative value, but only if the victim comes to the court and gives the. So that was the video for today. I hope you like this video. If you like this video, don't forget to like, subscribe to our channel, and also share it. We'll be coming with more educational videos. Till then, stay tuned. This is Ashna Viraja signing off for today. Bye.